We are back with Cameron Wilson, partner in the Employment Law Department, and he is going to be digging deeper into the labor of immigration law and how he will assist employers and employees in dealing with matters involving the Department of Immigration. You've mentioned criminal process quite a lot. I'm interested to know who's actually conducting these raids at the employer premises. Is it SAPS or is it another state entity?
So it's the Department of Immigration.
Okay.
Often accompanied by SAPS.
Okay. So that's where the criminal process would then come in for the employer.
Yes. So you then get charged for contravention of Section 49 of the Immigration Act.
Okay.
Which makes it a criminal offense to knowingly hire an undocumented or illegal foreigner.
Okay.
And then we get onto that criminal aspect where what's important is the knowing. You've knowingly hired someone that is undocumented. It shows that intention. You need to know that they don't have their documents, but still proceed to.
Yeah.
Yeah.
So on the day of the inspection, how would it play out? Is an employer given an opportunity to say, these are my representations. This is the due diligence that I've conducted. These are the documents as I know them. Or is it judged by the Department of Immigration based on, as it is in the file, this is how we're taking it, and then whatever representations are going to be made by the employer would have to be made in court?
So practically, and this is why I'm focusing on this, in my experience this has happened for 3 big clients in the last month. Immigration conduct an inspection. There's no opportunity for representations because they've got evidence which shows that they are undocumented or at least falsified documents in the employer's possession. They don't generally ask, what have you done to prove this? The employees and then whoever is responsible for the plant or the workplace gets detained. And ideally, and it's been difficult to sort of set out exactly to clients on how the process unfolds because I've had 2 different situations. One client was detained and was put in holding and given bail the next day. The other client was given a notice to appear in court. Both clients were charged with contravention of Section 49, but there's a risk that you may be detained. And we've instructed counsel to give an opinion on whether or not that's correct, but we haven't got to that stage yet. But the point remains that there's a risk that you may be detained and you may be required to give bail the next day.
Okay.
And I don't believe that's a position, from my experience, that any employer ever thought that they would be in, because I think over the last few years, generally speaking, especially dealing with general workers and given the informal employment, some employers don't realize that they too may be liable and take that risk. They just simply believe that the foreign employees may be arrested and that they may be liable for a fine, but I don't believe it's come as a surprise to everyone that you may too be charged and arrested. Yes.
So you've mentioned evidence, and I'm interested to know from an employer's perspective and also from the perspective of an employee who is documented, who's permitted to work, perhaps they're on a critical skills visa. Does the Department of Immigration work on a tip-off, or does the Act give them the right to conduct a raid as and when they deem fit?
They are given the right to conduct a raid as and when they deem fit. Okay. Generally, though, it's given by tip-offs. And again, on the practical sense, often when it's arisen where there's 2 unions involved, one is vying for majority or even just to get representation, and it's always broken telephone as well. It's one employee, just based on the investigations we've done, it's just broken telephone where the numbers get inflated, and before you know it, 500 undocumented foreigners are working at a workplace. Yeah. But yes, so you can, again, in a practical thing I say to my clients is, whilst getting your affairs in order, deal with your employees on the ground. See if there's any unhappiness with the fact that there are foreign employees there. Deal with the union, engage with them, if you can. And I've done that. I've dealt with unions, and the unions have foreign employees under their membership, and they're quite happy to. But it's those where they can see something's going wrong, and it's not being dealt with and not being affected. That's when the tip-off comes, because someone needs to intervene in these situations.
And in terms of engaging I would imagine you would need to engage meaningfully and also, to have consensus at the end of the day, because the principles of fairness and equity from labor, the constitution have to be prioritized. Who is best placed to facilitate those engagements? Would it be attorneys such as yourself, or would it only be between employer-employees?
Generally speaking, I think it would be between employer and employees, but with the assistance of the attorney.
Okay.
Generally, the union will get their backup, I think, when an attorney enters in a negotiation. But I think it's almost critical that you have your attorney advising you. Because what will end up happening as well is, remember, this comes down to negotiation again. And the union now is able to flex its muscle because you've come to it in a bit of a predicament. And you don't want to get yourself locked into some sort of wage agreement or benefits that you're not happy to give up, but you're scared of.
Or that you're not even aware of.
Yeah.
So as an attorney, how would you assist in that situation? What are the key topics that you're going to bring up? Are there topics that you aren't allowed to bring up? Is it strictly focused on immigration?
I think it would be to identify what the source of the potential complaint is and to sort of demystify any of the impressions or thoughts that the workforce have that the employer is hiring more foreigners than it has, that it intends to keep them indefinitely. Because again, with my clients, there is an appetite to have their workforce entirely local because it's less of an administrative burden. But it takes time.
Yeah.
And again, everyone has the right to fair labor practices. So it's difficult you can't just retrench because you're an undocumented foreigner. You can't just terminate for those reasons.
Because then we'd have to go back to the LRA and see what the LRA actually allows for you to do.
Exactly.
So your presence as an attorney, would it be before the department has raided, or are you also able to be present even after the raid and facilitate engagements with the department if necessary?
So since the practical examples that I've given have happened, I've engaged post-raid, but going forward now, some of our clients have taken on board, let's get the attorney involved beforehand so we can make sure our house is in order. And then if we are being inspected and we're unhappy, the attorney can at least attend on site, is aware of our affairs and is able to liaise properly with the department.
Okay. So there seems to be a lot happening on the ground, a lot happening in workplaces. And given what you said about the uptake, about immigration being strongly enforced, I think it's important that people understand the role that attorneys such as yourself play. And I'd like for you to take us through how exactly you are able to assist both employees who want to ensure that they are not circumventing the law, but also employers, given the strong obligations that are on them in terms of the Immigration Act.
Yes, I think it comes in that practical, and the benefit of having the employee as well is you get that objective advice. We highlight the risks, and we know our clients may not like to hear the risk because it does come with more effort and more of an admin burden. However, we are able to then draw on the practical examples that we're seeing. I've got, like I said, the main matter that I'm dealing with was a good client who tried to be proactive and still fell short of what is being imposed on it by the Department of Immigration. And so the attorney's presence, in my opinion, it allows HR, whoever's handling that process, to have an expert in the field who can provide that objective advice, may have the correct contact person to contact at the Department of Home Affairs, and may also then be able to motivate that someone just simply goes and sits at Home Affairs with the documents and gets a name and gets a reference. And then the benefit of all of that is your attorney or whoever's handling it for you, if you are inspected, if the worst possible outcome happens, you have someone on the ground who is able to and is well equipped and informed of your current situation and is able to then engage and make meaningful representations at the time, be it to SAPS, be it to the public prosecutor, or be it to the Department of Immigration. And we've had quite a bit of success with that. That's something I have found. I found it quite difficult at the beginning to be on the back foot and work and acquaint myself with the affairs as I went. But with my client, and based on, unfortunately, the first case that occurred, which then gave me the experience and the know-how on how to handle it. When my other clients then got inspected, because I had been engaging with them from day one, it was quite easy to mitigate on the ground and handle it. And it was actually the difference between general manager being detained and not being detained. And the process then unfollows, and the charges hopefully get withdrawn.
So I think that's the key takeaway from today's episode, everyone, is for employers to be proactive from day one and to ensure that they engage with attorneys such as Cameron, who specialize in immigration within the workplace, so that they make sure that they're on the right side of the Immigration Act. Thank you so much for joining me on this episode of Off the Record with myself, Unati, and we do look forward to having you on the next episode.